He still is.
He still is. You know, I certainly want to have 2 lines for an argument.
Even his arguments are getting cut. That's one chance we just make it very ridiculous. And so, yeah, I think that's cool. Because that is. That actually doesn't explain a lot. That's why. I think I'm not saying I know that for a fact. Well, that is years ago. But then,
All rise. Oyez, oyez, oyez. The Court of Appeals of the 4th Appellate Judicial District is now open pursuant to law. Morning.
Morning.
Good morning. I'm Justice Lori Massey Brissett, and I have Justice Todd McCray and Justice Velia Meza with me. Before we begin, I want to thank you for being here today. I know this is an extremely unusual situation for us to have granted oral argument when neither party asked for it. The TRAP allows us to do that in the appropriate case. We felt this case was something that we needed to address a few matters. I want you to know it will not be an ongoing request. We understand this is an extraordinary measure. So thank you for appearing today. I'll ask the council to make announcements and introductions. Thank you. Ms. Gorham, please proceed. Oh, I'm sorry, Mr. Krithian, please proceed. Let me call matter 424-653 CV in the interest of A.C.P, A.I.P, A.M.P, M.J.R, 3 and M.C.S. I ask the appellant to proceed.
Presiding Judge, Honorable Justices, may it please the court. I'm counsel Albert Gutian for the appellant, Monica Sanchez. This case starts with a snake, like the Bible, but it goes down pretty fast from there. I will go through the trial transcript real fast and just review the evidence that Mr. Robertson put in his case in chief.
Actually, we're very familiar with the record on the evidence. Why don't we jump to the first issue about whether we can consider the affidavit? Let me ask you this question first. Would you agree or not that if we were to be able to look at the affidavit and the facts stated therein, that there would be sufficient evidence under D, which is endangering the child?
No?
Okay. Do you believe we can look at the affidavit?
You can look at it, but I cannot look at it because I cannot cross-examine the other party. They are not in court. I have no chance of talking to the signatory of that affidavit and contest or discuss about it, cross-examine and test all those findings within the affidavit that later on the court is basing this very serious judgment terminating the parental relationship.
Have you looked at the cases cited by the state?
Have I looked at the case?
The letter brief that came to the court listing cases that were in the court did look at the affidavit.
Oh, the one that they filed yesterday?
Yes.
Yes.
Could you discuss why those cases would not apply?
I would go back to the hearsay. That's what I'm saying. I can't test anything. It's not in court. A lawsuit is decided in court, not outside of it.
Right. Right. I realize those cases go to whether we can consider it under O specifically, correct?
And oath doesn't make any difference to me. I'm not denying or contesting the authenticity of that affidavit. What I'm contesting is the mental state of the person, what they saw, and whatever they put in that affidavit. Because if the affidavit is the only thing that leads to termination, the affidavit was not even discussed in court. Actually, in this case, none of the exhibits were even mentioned. There was no mention of it was dumped 14 pieces of exhibits in a bucket and left there. Nobody talked about them. I mean, Mr. Robertson talked about 4 things in his examination of Bianca Montejano. And he also talked about 3 more things with another investigator, Michelle Saldana. And then on page 53, the state has rested. I mean, it's like the case was decided elsewhere and they just met in court to wrap up the loose ends or something. Or just let's do it how we agreed on it. I don't see any evidence at all. I don't see endangerment.
What about the sexual abuse that 2 of the daughters alleged they were sexually abused and the mother supposedly either downplayed it or didn't believe it at first? Don't you agree that that's endangering those girls?
So that's another hearsay. That's another statement that nobody could test. And it was Ms. Saldana's, I think, opinion that the mother was surprised, the grandmother was surprised, and the aunt was surprised. It doesn't say anywhere that they denied it or that they said this is a lie or nothing. And this is an RTB. I understand it's just an allegation at this point. And
So you don't agree that's a reason for a court or a trial court to think that the girls were endangered and meet the burden there?
no, not at all. I don't think this is endangerment. They're entitled to their opinion. And I understand that Mr. Postel, who's the RTB person, was not in contact with them. He was not doing anything in this case at all. I mean, in my opinion, this case it's a poor person, like the Miss Saldana said, rough looking. So this is a poor, ugly woman, in their opinion, who just let's take away her kids.
So, but you do have the fact that 3 kids were injured, right? And that the mom tested positive for cocaine prior to the removal. Is that not sufficient? And if not, why under the law?
Now, the kids were, if we delve into the facts, the kids, one of them was bit by a snake. They presented no proof that it was a snake. It could have been a rabbit, because the mother said it was a rabbit, not a snake. It could have been some other animal. Nobody put forward any evidence of what happened over there. The other one was bit on the thigh, but nobody knows where. Again, it's just some words thrown in. There was no discussion about this in the case. And then the allegations of sexual abuse, I mean, those are allegations.
But it was unobjected to at trial, right? Like the counsel for mother never objected to the hearsay, never, I mean, what do we do on the legal sufficiency or factual
That's right. We
sufficiency
could say,
review?
oh, too bad. You know, nobody objected. Let's take
But what
away
does the
her
law
kids.
say we have to do? That's my question.
The law says that a lawyer should object to everything.
So as a court of
Mrs. Hanson?
appeals, if you have to write this decision, how do you overcome the sexual abuse allegation?
So the sexual abuse allegation is just an allegation at this point. I don't think this is a proof of endangerment just because mother and the 3 ladies acted surprised. It's a child, it's a 4-year-old child who makes this allegation.
Was there I didn't see any evidence that she was still in the relationship or that he was around the children at the time of removal, right? Is there?
No, I haven't seen any, none of the parents, none of the fathers were there. And there was another problem. They brought all the fathers and lumped them with the mother. It was not good. By irradiation of this bad prestige, she was just lumped in there. And in 5 minutes or 10 minutes, she was terminated together with the other one. It was a wholesale business. It was very efficient. I don't know, 5, 6 terminations in 2 hours.
let me turn to the family service plan. And we're gonna have time to talk to the state about some concerns we have with the family service plan, but we always end up back to the fact that mother did nothing to try to comply. Is there anything we're missing in terms of mother's attempt to comply?
Yes, I think so. First, they presented no proof that she did nothing. They took away the kids, put them in some centers somewhere very far away from her, then berated her because she moved from Converse to Selma, I think it's very close. Also faulted her for not having a car, faulted her for being in jail for a while, and why is she not visiting the kids from jail or something like this? And they presented no proof as to the visitation. They're saying 13 visits out of 48, which is like 30% or something like this. But the mother is also claiming that some of the visits were canceled by the department.
How would the Texas Supreme Court RJG opinion apply here, given the facts relating to the family service plan?
I can't recall the RJG opinion
Okay.
offhand.
Was the mother ever, do you have an understanding from the record of whether the mother was aware of and understood the family service plan prior to her incarceration?
I think she understood it. She tried to comply with it. Everybody's, if you look at the transcript, everybody's saying very good things about her. She's got a very good relationship with the kids. She's a good mother and a caring mother. This is what Bianca Montejano says. This is Miss Saldana says. She tried. She had no car. She had to walk like a mile to the bus. And then the meetings were canceled. And the biggest problem is, let's say, for the argument's sake, that the mother was a bad mother and didn't care. They didn't prove any of that. I don't see in this case any proof that she didn't comply. I don't see any proof that they tried to accommodate or provide services for the mother. Ms. Saldana says that I tried to give her a bus pass or something. I'm not sure. Provides no proof of anything.
So one of the things we put in the letter to you prior to oral argument was that we wanted to discuss two things, the affidavit and the family service plan, and specifically whether there needs to be a connection between the items in the service plan and the reasons for removal. Do you have any discussion that you want to offer on that?
So, the service plan is something that the court puts in place for the kids to be returned. So if you disagree with the service plan, basically you are upsetting the court and insulting the court. And this is what the case is. I mean, the judge was upset because she did not comply with some of the requests in there. And also, she was in jail. I mean, they should take that into consideration. And no, I think she tried to comply with it. I think she's, up until the kids were 12, nobody told her that she was a bad mother or that she wasn't taking care of the kids. It had to, for the department to show up and take away her kids and put her under some sort of plan, which was, that plan should have been only put in place if they proved endangerment and abuse. But there's not a single instance of abuse here. A snake bite?
Excuse me, let me ask you, under endangerment, under D, how do you address the fact that mom tested positive for cocaine? Wouldn't that be enough under endangerment? And do you believe the record establishes that she did test positive for cocaine?
In court? No. I don't see any proof that she tested. I don't see any medical opinion. I do not take Ms. Saldana's or the investigator's word for it, that she tested, that they've proven it, anything.
So you don't think her testimony that mom tested positive for cocaine and the statement in the family service plan is sufficient evidence?
She's not a doctor. She's not a drug specialist. And Ms. Hanson, the lawyer, she did not contest anything. So basically nothing comes into court. nothing, or nothing should come into court.
Are you saying Ms. Hanson didn't do her job?
I'm saying Ms. Hanson is doing her job as much as she knows as a non-attorney. And no, I can't fault her. I'm faulting our lawyer, Hanson.
Hmm.
Ms. Hanson, she basically offered zero objections, nothing. A lot of the discussion in the transcript, it was about some story. It assumed a gigantic amount of information and facts that were not put in there. It's like we are hearing a story that was debated elsewhere and just assumes so many facts, but nothing in evidence. A lot of assumptions. Drugs, bites, rattlesnakes. There's no proof of any of that. I mean, I'm an outsider to this case, and I'm looking just at the transcript, just like you are doing. I don't see anything in there. I just see it's hot in the summer, says Bianca Montejano. There are 5 children in the home. They lived in a restaurant with a hole in the wall. They have no proof that there was a hole anywhere, in the hole or in the ceiling. There's no proof that she got bit by a snake. Could have been something else.
Are you taking the position that we can't take the testimony of the caseworker as true?
You can take it if you believe her. I don't believe
Well,
her.
don't we have to assume that the trial court did believe her? We're not going to reweigh the evidence for the trial court, right? That's the trial court's determination of the credibility and the weight to be given the evidence.
That is true, but I think that belief is not reasonable based on the transcript. Had I been the judge, I would not have approved any of that without proof. The termination of kids is something that parental rights is something very important. It's not something, it has to be very specific, has to be very strict. There was nothing strict in here. It was like a conveyor belt. Johnny terminated. And some of the lawyers even left early because they were busy with something in this case. And I don't have proof, but I think our own lawyer left for a while and she came back.
But there's no claim for ineffective assistance of counsel
Yes,
here.
we do have that too.
Is it in the brief? I didn't see that in the brief.
I think it is.
Ineffective assistance of counsel?
Yeah.
Well, I'll tell you, the reason we're here is because we have a very strong concern about the record. So we appreciate what you're saying in that regard. But I do want to get back to a legal issue before your time is up. And that's going back to the family service plan. In NRA EJC, we specifically talk about the fact that there should be some relation between the requirements of a family service plan and the reasons for removal. And the Supreme Court has echoed that concern. But in this case, the family service plan was introduced and admitted into evidence without objection and made an order of the court as a reasonable plan. So given that, can we look at the requirements of the family service plan and disregard noncompliance with things that we find have no relation?
Completely. I would disregard the family plan because it was based on no proof. It was not necessary for one thing. And then if you don't have any instances of endangerment, then there's no need for a family plan. And then
Well, we could affirm on O, even if we don't affirm on D. So it still goes back to the family plan and whether she complied, even if we said no to D, correct?
yeah, but non-compliance with the court is so just a second. Well, she didn't complete all the services. That's true. We're saying that the services should not have been put in place. Mother was incarcerated a little bit. And she completed an initial drug test. She went to some classes. But I think that the department set her up to fail in this case. They rushed to terminate because the plan wasn't finished. Another problem was that they they said, okay, it's been a year. Okay, well, 1 year, that's all you get. She asked for a little bit of time, it was not granted. And, no, I don't think you should, perform on ground O, comply with the court-ordered, service plan. For example, this one applies only if the child was removed due to abuse or neglect. And
And that's where the cases say we can look at the affidavit to determine whether she was removed for allegation or neglect.
yeah, this is
correct?
like the theory of the snowball. It just goes downhill and it becomes bigger and bigger and bigger. If you start with an affidavit that it should not have been admitted, then you get removal, you get termination. It just blows up out of proportion from one seed. It's like the poisonous tree doctrine here. Yeah, one poisonous seed, you make a big tree out of it. That's what happened. I mean, that's my opinion. I'm looking at the transcript. I don't see anything in there. I mean, I don't see any. This mother could have been the worst mother in the world. They proved nothing. I don't see any proof in there that I can rely upon. I see non-lawyers, non-experts testifying as to expert issues and talking about drugs, talking about Miss Saldana says that she feels like they are unsafe. It's a feeling. You don't terminate for feelings. The other one says okay, my time is up. Thank you.
Thank you, Mr. Curtian.
Thank you.
May I please the court? If you'll allow me, I'd like to go through the two issues that were brought up in the letter that this court issued on February 20th of 2025. In those two issues, I kind of read about 5 questions that y'all have about the record. And so I've structured my argument to address those things. And if there's something that I missed, please stop me and ask. The first question that I see raised in your letter is whether you as a court can consider the affidavit in support of emergency removal and support of termination under D. And the short answer is yes. The state filed a letter yesterday, which has been referenced with a supplementation of citations to cases on which the court used the affidavit to determine whether or not a child was removed for immediate danger to health and safety under 262.
I thought they were all under O. Is there any case that has said beyond O itself?
So those cases focused on the original reason for removal, not the reason for termination. So they don't, I don't believe they all fall under O. Some of them deal with D. I believe the one for the Supreme Court deals with D.
Which one is that?
That is. Henry ECR, 402 Southwest 3rd, 239.
So going to Mr. Curtian's statement is probably where my concern is as well. Obviously, we're trying to look at all the evidence that we should consider to determine the best interest of these children. And there's certainly more evidence in the affidavit than was presented at trial. But under D, respond to Mr. Curtian's statement that given the import of the rights here, the constitutional nature of terminating someone's rights, should we be considering evidence to which she had no opportunity to object or cross-examine when it's offered for the truth of the matter asserted under D?
So the evidence contained within the affidavit is minimally also exactly what she testified to at trial. So she was subject to cross-examination on the things that were contained in the affidavit that she testified to at trial.
But there are additional facts.
There are additional facts. If it helps the court, when responding to a parental termination brief, never read the affidavit. So my entire brief is based only upon testimony given at trial. So
So
I-
you're intending we don't need to look at the affidavit?
I don't think you need to look at the affidavit, no. And if I may, moving on to your second part of the first question that you issued is evidence under D sufficient without the use of the affidavit? My contention would be yes, and I'd just briefly like to touch on why. The living conditions in that home were not the only reason why those children were removed. But the living conditions, as you've seen from reading the record, were quite bad. They were unsanitary and unhealthy, causing the bites to both of the girls and the extreme heat for the 3-month-old baby that was living there. The second reason why those kids were removed and endangered is because the eldest child ran away from the living conditions, was stabbed, involved in a criminal offense, and required surgery because of the stab wound he received.
So let me stop you because I feel like you're going beyond the record. There's nothing that he's saying he ran away. In fact, the evidence is that mom knew where he was, and there was no evidence as to the character of the people with whom he was staying or the condition of the home in which he was staying, correct?
There is no evidence as to the character of the home he was staying in. There is evidence on the record that mom knew his whereabouts. That's on page 24 of the record. There is evidence that he was stabbed, hospitalized, and involved in a criminal offense. That's on page 28 and 29 of the
Is
record.
that enough? Don't you have to tie it some way? And the snake bite too, is injury to a child enough, or do you have to tie it back to the act or omission of a parent?
I think that the injury to a child considered with the other 5 things that I would list underneath is sufficient for endangerment. And so it's a totality of the circumstances. It's not a one-off. It can be a one-off under D. One thing can be enough to endanger a child. But in this situation, we have far more than one thing that endangers a child.
But if each one of those things by itself is not sufficient evidence, is considered no evidence because you don't tie it back to the parent, then you can't bring them all together to say in totality, they're sufficient, right? There has so for example, injury to a child by itself, is it sufficient? Is the testimony of a single drug test, is that sufficient? You can't, would you agree, you can't pull a bunch of things that are no evidence together and say all of a sudden there's evidence?
You can't look at this in a vacuum. You have to look at it together. And so you may think that one thing is not evidence, but all things together can certainly create evidence of an endangering situation. And so if I may return back to the argument I was making earlier, the living conditions, the status of the eldest child, the substance abuse issues, not even the fact that there could have been a positive test, but the fact that there was ordered tests and they were not taken. So the substance abuse issue remains unresolved. And so therefore, there's potentially an issue of inappropriate supervision going on.
Was there any evidence of the drug tests that were asked that she didn't comply with?
Besides the testimony given that you alluded to earlier in questioning Mr. Kurtian, no, at least outside the affidavit. If you consider the affidavit, there is additional evidence.
Right.
There's evidence that there was not a stable support system, and therefore the mom had no one else to rely upon to help her. She couldn't give the department anybody else's name of someone that could help support her children. Her mother watched the children when she worked, when she had a job, but mom was also alleged to potentially have been involved in that drug use as well, and that was never cleared up.
So let's go to the evidence at trial, because let's assume we cannot look at the affidavit. Evidence of whether she had a stable support system, grandmother. Is there any evidence that there was a valid concern about grandmother? What is the evidence?
There's testimony to the fact that grandmother potentially used drugs, and there was never cleared up whether or not she used substances.
So is the allegation that she might have used drugs sufficient to say she was not an appropriate caregiver without any evidence that she actually did?
No, but it's not sufficient to say she is an appropriate caregiver either.
But it's the state's burden.
I understand that.
It's the state's burden to put evidence in a record so that we can review it to determine the best interest of the child.
I understand.
So I'm asking you, was the evidence presented at trial? For example, the aunt, when the only testimony regarding the maternal aunt was that she wasn't appropriate, period. That was it.
The testimony regarding the aunt was that she knew of the sexual abuse allegations, did not believe them, and failed to report them. And that's on page 48 of the record. So that makes her an inappropriate supervisor or someone to watch the children.
Yeah. So I have a question about, and I'm glad you brought this up earlier. I have a question about the reason to believe relating to the sexual abuse. It happened prior to removal, correct?
Yes.
So all we have in the evidence is that there's a determination of reason to believe that happened months before the removal, of which the department did not do further investigation or take further action on. Is that sufficient? without any evidence that the man is still in their lives and poses a danger?
Not by itself, no. But when considered with the whole list of other things that caused endangering conduct to occur with the children, yes, that's the state's opinion. It's discussed in the record on pages 34, 38, 47, and 48. The reason to believe sexual abuse and the fact that mom had him around the children, despite the fact that she'd been told about those allegations and chose to disbelieve them. But then we also come back to the last thing under the endangering that needs to be considered, and that's mom's criminal history. In the record itself, it's very clear that she's incarcerated for approximately 3 months prior to trial, and that she's incarcerated on 3 different types of cases, all of which are potentially, 2 of which are potentially felonies, maybe 3.
I don't remember that from the record. The
Oh.
only thing I remember from the record is that she was arrested for evading arrest and she was facing a motion to revoke because she attempted to steal a car.
I will find it, Your Honor. I have it written down somewhere.
Yeah, what I'm concerned about is actually what Mr. Curtion alluded to, is that the parties were all, sometimes when things are in your head because you know a case, it's considered even though it's not presented at trial. And the question that we have to answer, the question we are bound by is the evidence presented at trial sufficient to meet the state's burden? Because we're dealing with a constitutional right involving a parent's right to parent their child.
Yes.
Right.
And I would just say we need to return to the standard of review in the way that you approach this case. Legal sufficiency requires you to look at this evidence in the light most favorable to the termination.
Great.
Factual sufficiency requires you to give due consideration to the evidence that the fact finder could have found to be clear and convincing. And it also requires you to disregard all of the evidence that judge could have disbelieved or found non-credible. And so when you come at it from that perspective, I think you have to see that there is sufficient evidence. But if we turn to your,
Or clear and convincing for a firm belief?
yes, Your Honor. I would like to address the other question in your letter, but in between addressing this and that, I would just say, in all of the questions that have been asked, we've completely disregarded the fact that there is another ground for termination that was proven at trial. And doesn't seem to be any issue with it either from appellant or the court besides what's in the brief.
Talk about N.
Yes, and the state only needs to prove 1 ground for termination and best interest. And best interest only requires 1 ground for termination to be proved. And I don't think that there's any problem with the proof under N.
Let me ask you a question about that, because
Yes.
under N, one of the prongs to be considered is whether the department made reasonable efforts to return the child. And that 2 things that we should look at is, did they try to place the children with a relative? Did they accurately look at mother or the relatives? And 2, whether they put in place a family service plan to which she could comply and get the kids back. So I've already asked questions about the fact that, was there sufficient evidence that mother or maternal aunt were not appropriate caregivers if the only evidence issued was the statement that they were not appropriate? But the second one goes to the family service plan. And I want to ask you a question about that, because I'm really concerned about the recent Supreme Court opinions, such as RJG, such as the Chief Justice's statement in the state of judiciary about O. But N relies upon a family service plan. And in this situation, you have a family service plan that was not signed by the mother. There's no evidence that it was done in conjunction with the mother. There's evidence that the state intended to revise it, but there's no amended plan that was communicated to the mother. How does this family service plan surpass the requirements of RJG?
So are you referring to RAA?
No, I'm referring to RJG. It's specifically where the Supreme Court goes through and says what a family service plan has to do. It has to be signed. It has to be done in conjunction with the parent. It has to be that the parent understands the ramifications. And in this case, we have a family service plan that was presented to the court and made an order of the court, presented as an exhibit at trial, that was not signed by the mother. There's no testimony that the mother was given a copy of it, that they worked with the mother to determine what needed to be done. The mother understood it until she was incarcerated just before trial, and she immediately started complying.
So mom didn't object to the entrance of that service plan at trial, so we have to consider that as evidence because it was admitted as a court order. Mr. Kirchian also told you from this podium that mom understood her service plan. So if
There's no evidence of that.
then we can't take him at his word either. If there's no evidence in the record, then him saying she understood it also doesn't matter, I guess, is what I'm trying to say. But when you talk about reasonable efforts to return by the department under N, it's not just the service plan, but the service plan is part of it. And in this case in particular, the court found on the record, he made a finding of fact twice that the court had made reasonable, that the state had made reasonable efforts to return the children to the mother. And he listed 4 things that qualified as reasonable efforts. And those are on page 72 and 73 of the record. The service plan, the setup of virtual services that did not require transportation, rides to see her children at scheduled visits, which testimony showed she used on occasion, and the installing of a new AC in the living space. And so the trial judge made a finding of fact on the record that those were reasonable efforts to attempt reunification. And this court, those are partially credibility determinations based on the testimony given by people at trial. And that can't be revisited at this point. So we have to rely upon some of the determinations made by the trial judge to trust that the testimony he received going towards those reasonable efforts was credible.
Well, we have to certainly, as you said, view the evidence in favor of the findings, but we also have to find that there was sufficient evidence for the finding to be made, right?
Yes, Your Honor. And so turning to your second point in the letter, I read that to have 3 questions in it. The first would be, must there be a relationship between the services set forth in a family service plan under O and the reasons for removal? My response to you would be no, but if there is no relationship between the services and the reasons for removal, testimony might not be probative of best interests. Okay, so.
That's EJC.
And
Yeah.
correct. And in worst case, it's conclusory. So you quote EJC, which has the conclusory evidence, but I would recommend looking at Henry DBT, which is also out of San Antonio. It's 2015 Westlaw 1939072. Termination in that case was based upon O and a failure to complete a parenting class. And the child in that case was removed due to abuse or neglect, and the failure to complete that course was significantly probative of the child's best interest. And so a ground for termination might be probative of best interest, but it doesn't have to be. And that goes to the second question in the letter, which is, must the state show the failure to complete services affects the children's best interest? The answer is no, because best case, we show it is, and it's probative of several of the Hawley factors. Worst case, the state doesn't show that. It's not probative of the Hawley factors, and the evidence to show best interest comes from somewhere else in the record.
So I want to make sure I understood what you just said. You said if there's no relation, if the failure to comply does not go to a reason for removal, we can still take that into account in terms of best interest. Is that what you said?
If the reason for removal does not have to be related to the family service plan. But it helps when it is, because it means it's probative of the issues for best interests.
So it's probative as to whether the parent was complying with the state, but we're concerned about, just as the Supreme Court is, we're concerned about the state putting in place family service plans that have nothing to do with the reason for removal and are so onerous, it sets a parent up to fail. And so I'm concerned about what you just said, because basically you're saying the state can list 10 things that have nothing to do with the issues in the case. And if the parent doesn't do them, meaning they just weren't compliant, we could still terminate.
You can still terminate on other grounds. And in this case, that's kind of where the argument needs to go, because there are 2 other grounds for termination that the trial court judge used to terminate. And so in your question of saying, if that we fail to show that the completion of the services affected best interest, can there still be sufficient evidence for termination? And the answer is yes, because there's 2 other grounds upon which termination is based, D and N.
But not under O. You're
Correct.
saying under O, you need to have some connection or relation between.
I'm saying under O, it's helpful for there to be a connection so that there's probative evidence that goes towards best interest.
Mhm.
Yes. And finally, to address the last issue, did the mother present sufficient evidence to demonstrate her inability to comply under D? The state's response is that this wasn't preserved for appellate review at the trial level. It's an affirmative defense, which the Texas Rules of Civil Procedure require to be specifically pled, and it was not specifically pled here. However, if we assume that it was specifically pled, she still fails to meet her burden because it's her burden under the affirmative defense. She failed to identify specific sections of that service plan she was unable to comply with. She failed to give reasons that were not attributable to her fault as a parent. Even if we assume her reasons for noncompliance, and we'd have to be straight up assuming because we don't have evidence of them, even if we assume the reasons for noncompliance were lack of transportation and lack of financial stability, those shortcomings don't explain her being in jail for 3 criminal offenses, potential drug use, the lack of protective instincts around her children, her child being stabbed, the 2 children being bitten by snakes, the sexual abuse allegations. Those things are all solidly attributable to the fault of the parent. And so even if we
How
assume
are they attributable to the fault of the parent?
the parent does them, it's
The
she
parent didn't
affirmatively
injure the child. And that's what we're looking for. Evidence in the record that ties these injuries back to an act or omission of the mother. That's what can you show me something where you're tying it back to the act or omission of the mother? I mean, the fact that a child is bitten by a rattlesnake in Texas does not mean a parent should have their children removed, right?
No, nor are we alleging that because we're not allowed to allege that. Under C, on 161C, the financial instability and the unsavoriness of potential living conditions are not a reason to terminate rights,
Right.
which is why in the initial argument, I went back to all of the list of reasons why there was an endangering environment. And together, those things create endangering.
Let me
not-
ask you a question because clearly we're concerned about the record, right? And we were concerned about bringing you here today because we know your resources are taxed with cases like this. So we certainly didn't want to do an unreasonable imposition on you, but we're concerned about the record in this case. And so it seems like the state is so taxed that it was unable to present the evidence that it needed to at trial. Is there any other reason that the record would be so thin in terms of even the fact that if there's additional evidence in the affidavit that was not presented at court?
I would respectfully disagree that the record is so thin that this court is unable to come to a decision. I can't speak to the prosecutors who tried this case. I'm not in their shoes, but I cannot give you a reason why the record stands the way it is other than to tell you I don't think it's insufficient.
I mean, you guys called 2 witnesses at trial, right? 2 witnesses. And if you remove from the record all the going around the room, all the different lawyers objecting or not objecting, what is the substance of the record? It's probably less than 30 pages. I mean, that's what you all stand on for clear and convincing?
It's what I have to stand on, Your Honor.
Thank you very much. Mr. Kurtown, do you have any rebuttal? That concludes the oral argument. Again, we thank you for coming. Clearly, this was an unusual situation that we are struggling with the record before us. We'll take it under advisement. Thank you.
Bye. Thank you.